we had Tara Lynn Bailey versus David Mitchell Bailey Jr.
For your Lee Jackson of Eddie.
Mayor Bailey, we have 3 motions pending today.
You want to have your client have a seat? I have the first one is a motion to dismiss the father's petition as moot.
Yes, Your Honor, we can start there. Just a nature of background for the court. This matter's been pending since 2019. We have a trial set in 2 days in front of Your Honor, November 5th, day after tomorrow. There are 3 petitions that are pending for trial. It's the father's petition for to modify child support and to terminate or reduce alimony, mother's petition for civil contempt for enforcement of the final decree of divorce for attorney's fees and costs, and then father's petition to enforce the parenting plan. Starting with the motion to dismiss father's petition as moot, as I said, one of the petitions is to enforce the father's parenting plan, to enforce the parenting plan, but there are no more minor children in this case, Your Honor. All the minor children have emancipated. The last one graduated from high school this past May, so child support has expired, and we just have to figure out how much it is. But at this point, we'd argue that that petition is moot, and there is no more. There's no longer a parenting plan for the court to enforce. Should I go on to the next motion, Your Honor?
You may.
Okay. The other motion is the motion to enter child support worksheets nunc pro tunc. So as you'll recall, Your Honor previously referred us to a special master hearing to resolve some of the issues that have been pending. We had the hearing. Both parties filed exceptions to the special master's findings. We had a hearing on those exceptions, and on February 12th, 2024, Your Honor entered an order which ruled on each party's objections and modified the findings of the special master. Your Honor modified some of the variables that were used to calculate father's child support obligation from February 2019 to June 2021. However, Your Honor's order did not include the new calculations or the child support worksheets that actually stated what father's child support obligations would be during this time. So for the order to be complete for that time period, we need child support worksheets to be entered that take the variables from the special master's findings and the ones that you modified and put that into the court's order. There are no factual issues left to be heard for those child support worksheets for that time period. It's just the actual calculations. And the first exhibit I'd like to enter, Your Honor, here's the child support worksheets that I attached to my motion. I believe this takes into account all of the variables and pulls them out of the correct places and enters Mr. Bailey's child support obligation. Here are the variables that I used. I'd like to mark that as the first exhibit, Your Honor. This is the chart that was in the motion. And it's a lot of math and a lot of numbers, which I hate dealing with. I've tried to make it as simple and as digestible as possible. These were the periods, the time periods in that first column going down that the special master, Your Honor, ruled child support will be modified for. In the third column, I've listed where I'm pulling the individual variables from, either the special master's finding or Your Honor's order that modified the special master. And then I've listed the new child support amount that should be entered based on those variables. So I believe I've done it all correctly. I try to make it easy for Your Honor. Mark that as the next exhibit, please. Our final motion today is mother's motion for discovery sanctions pursuant to Rule 3702. Three of the issues remaining before the court at trial are the calculation of father's child support obligation from June 15th, 2021 through May 1st, 2025. Father's ability to pay during that period, and then father's present ability to purge himself of civil contempt by paying all the arrearages that will be owed to mother. To make these determinations, Your Honor will need to see evidence of father's gross monthly income pursuant to the child support guidelines and his finances from June 15th, 2021 to present. Father's gross monthly income in the party's last parenting plan order was entered in 2016 was $21,666.66 per month. Mr. Bailey's claim is that his gross monthly income has been reduced since that time, and that is the major crux of what will be heard at trial. And mother's position is that father's intentionally reducing his income for these proceedings and is making it up elsewhere, like company credit cards, like income for stocks that he owns. The issue of Mr. Bailey failing to supplement his discovery responses prior to trial has already been heard once before Your Honor. I'd like to pass up a copy of this order. So on July 1st, 2022, Your Honor granted our client's emergency motion to continue the trial and continued the July 6, 2022 final hearing so that the court could hear each party's objections for the special master findings and, quote, so that supplemental discovery responses can be provided and both sides can be prepared. That's on the first page of this order. I'd like to mark that as the next exhibit, please, Your Honor. Now, after that, Your Honor entered another order. Pass this up to the court. In this, the order regarding motion for scheduling order, highlighted there at the bottom, Your Honor, ordered that thereafter the court shall schedule a final hearing on any remaining issues and the parties shall supplement their discovery responses 30 days prior to the future final hearing date. Mark that as the next exhibit, please. That's exhibit 4. So we've had a hearing where Your Honor has ruled that supplemental discovery is relevant and necessary. And we've had a hearing and an order saying that it shall be supplemented 30 days before trial. Rule 3702, Tennessee Rules of Civil Procedure, states that if a party fails to obey an order to provide or permit discovery, the court in which the action is pending may take such orders in regard to the failure as are just, and among others, the following. A, an order that the matters regarding which the order was made or any other designated fact shall be taken to be established for the purposes of the action in accordance with the claim. B, an order refusing to allow the disobedient party to support or oppose designated claims or defenses, or prohibiting that party from introducing designated matters in evidence. C, an order striking out pleadings or parts thereof. D, in lieu of, D is just for attorney's fees and an order of contempt. In lieu of any of the foregoing orders or in addition thereto, the court shall require the party failing to obey the order to pay reasonable attorney's fees and expenses. Rule 3703 of the Tennessee Rules of Civil Procedure states that a party who without substantial justification fails to supplement or amend responses to discovery requests as required by Rule 2605 is not permitted unless such failure is harmless to use as evidence at trial, at a hearing, or on a motion any witness or information not so disclosed. In addition to or in lieu of this sanction, the court on motion may impose other appropriate sanctions, and this includes those under Rule 3702 that I just read. So the last time prior to this morning that Mr. Bailey supplemented discovery responses was on July 12th, 2022. And that wasn't even a complete supplementation. That was just tax return, 2022 pay stub, and a 2021 tax return. And the 2021 tax return was missing pages to it. Now, father once again has failed to supplement discovery before trial. We're 2 days before, 2 days out. But this morning I received an email from Ms. Roberts' office that had, and it was an email from March of this year that was forwarded to me that had his March year-to-date pay stub and his W-2 from last year. No tax return, no information going through at least May when child support would have expired, and none of the other discovery that would be relevant in this case, like his business credit card statements that he's using to make personal expensive payments on, and no 2024 tax return, and no bank statements showing additional income, which is what we expect it'll show. So we've got the rules of civil procedure and we have your court's orders. Both of them have been ignored. And here we are 2 days before trial, again, saying we don't have what your honors ordered them to turn over. During the 5 years that this case has been pending, we've consistently made requests that discovery be supplemented. Attached to my motion are, I believe, copies of 4 different letters from different years where we've requested supplemental discovery. We've been providing supplemental discovery as we've gone along pursuant to the court order. This case has been pending since 2019. I think this is the 4th time the final hearing's been set. And we're not asking for a continuance because we've already done that once. And we're asking instead that the court impose the sanctions pursuant to Rule 3702 and 3703. We're asking that the court do any or all of the following. It would be strike father's pleadings and award mother a default judgment, treating father's failure to obey the court order as contempt of court, imputing father's gross monthly income for child support purposes at the amount of that it was in the current order, the party's divorce. I believe that's $21,666.66 per month, and impute father with the ability to pay his court-ordered alimony and child support obligations from January 2019 to May of 2025. And that's for the civil contempt allegation that's pending against him, and impute his ability to purge himself of civil contempt and award Mrs. Bailey her reasonable attorney's fees. Thank you, Judge.
Robert?
Your Honor, this matter originated with me filing a petition to modify child support back in the last day of January of 2019. An answer was filed to that petition alleging that there was no basis for a modification. There was no, and we had also requested to terminate alimony. That became moot when the mother's remarriage. And when that was addressed with the special master to some degree also. But there was no allegation of willful underemployment in the answer. Thereafter, counsel on behalf of Ms. Tara Bailey filed a petition for civil contempt alleging 4 missed payments. That was it, just 4 missed payments in 2019. There's been no amendment filed to that petition for contempt. So we're dealing on the contempt for 4 missed payments. Your Honor, when it was referred to the special master, one of the bases in question number 2 that was referred to the master, the basis for the reduction of the petitioner's income, including any evidence of the petitioner's voluntarily underemployment, that was sent to the master and that was ruled on by the master. And the master found that there was no willful underemployment. So again, taking the master that there was no objection, the court addressed the objections that were filed in this. And the respondent's objections were, number 1, the respondent objected to the master's finding of the petitioner's 2020 gross income. The master found that Mr. Bailey's income equated to $12,684 per month, but based on his W-2, it showed a gross income of $164,350, plus other pre-tax deductions of $12,138, resulting in wages of $152 or $12,684. Respondent argues that the child support mandates the gross income. Your Honor reviewed that. found that the pre-tax deduction should have been added back in, and Your Honor set his income at $164,350, or set his income at $13,695.83. There is, we've already addressed the special master finding of willful underemployment, and it's wholly inappropriate to come back in when that was not raised in the objections, and Your Honor didn't reserve that. So again, my issue being is that in any issue, I'm going backwards with his arguments, on any sanctions for discovery, Your Honor, it has found my client's income is $13,695.83 as far as the master's concerned. That's it. We don't dispute that. That's a finding of the master. There was no appeal taken from that. And so again, there's not a dispute as to additional discovery on either part. Your Honor's found that Mrs. Bailey's income to be based on $20 an hour, and Mr. Bailey's income is $13,695. And so we took that as a finding of the court pursuant to Your Honor's order. And that's the issue. There's not as far as what his income in 2023 and 2024 are, is really not relevant to this proceeding. There's been a finding of what his income is. And so all of my issues were addressed in the special masters on the reduction. The only issue that we have to present, as Your Honor did in the findings, raise the issue that we objected, the special master found and assigned 0 days to Mr. Bailey. He was not awarded under the parenting plan 0 days, but because of the issue that arose in the marriage and the mother not forcing the residential time, and my client, again, not forcing residential time, Your Honor ruled that on the calculation of child support rather than on the master should be 365 and 0 rather than what it is. Now, I will point out, Your Honor, that was going to be an issue that was going to be argued, and why I do not want the motion to dismiss. We agree that all the children are now emancipated and 18 years of age, so there's no enforcement of that. But again, the parties in their marital dissolution agreement and the court order specifically stated, and they're contractually bound by the statement, that the child support shall not be modified. It's not just reduced as in the statute. It says the parties agreed, the parties acknowledge that court approval must be obtained before child support can be reduced or modified. So there is no pleading as to change the residential time. So again, I think Your Honor has to take into consideration that. But again, as far as the discovery responses are, I took it as res judicata, what your order said when it was filed on 2/12 of 2024. I did not take exception to it and ask for a reconsideration. I did not seek an interlocutory appeal, nor did the defendants in this case. And so Your Honor ruled what my client's income was, and that's what it is. So I don't think it's appropriate to come in and to ask and to relitigate the special master when it's already been adjudicated. So in our position, as far as updating discovery, that issue is done. I did not feel that there was a need to update discovery. We're not disputing that her income was set at $20 an hour, and my client's income was set at some $13,600 and some odd dollars. And I took that as the ruling of the court. Now, as far as again, their motion to dismiss our petition to enforce the residential schedule, we stipulate and agree that the children are all emancipated and have graduated high school. But again, that we filed that and we reserve that issue on the ruling of what days should be afforded to my client. But again, Your Honor ruled in your special master's report that that's what it was. And we didn't take objection to that. And so again, now the calculations of child support, his request for the introduction of child support, these are the numbers that Your Honor used, albeit that the 365 and 0 days are reflected in his, but these are the numbers that the special master found. So again, the scenario being is, I think these are the numbers. This is what the special master found. And again, once we have the hearing on Wednesday, if Your Honor takes exception to it, but again, based on the special master's finding, my client's income was set from February of 2019 until December of 2019 of $9,156, which Your Honor ruled on that he was entitled to deduct the $4,000 alimony payment. At the end of November, the then Mrs. Bailey got remarried. So again, that $4,000 was not reduced for the month of December. And so that equated his income back up. Your Honor modified her income starting in 2020 to $20 an hour. And those are the numbers Your Honor ruled after the exceptions to the special master. And I think we're all stuck with those.
You
One thing that I don't have the special, I don't have Your Honor, at least I do, let me see here. One of the orders, in the order that Your Honor ruled on the parties' exceptions, one of them, and I don't have it in front of me, was the special master's finding as to a child support amount in July of 2021. The special master hearing occurred in June of 2021, and Your Honor said in the order that the special master erred in determining July of 2021 because that wasn't before him at the time. So I would argue, Judge, that everything is open since June of 2021, when we have had, Your Honor has heard the facts, or the special master's heard the facts on everything between February 2019, when this case started, and June of 2021, when we went to the special master. Everything after that is open. The proof has not been put in, and that's what we're going to do at the trial in this cause. These children, the last minor child emancipated in May of this year, so we have a finite date where evidence is going to be submitted when Your Honor needs to make a determination on child support. I would absolutely disagree that the June 2021 special master hearing established the parties' incomes all the way to May of 2025. That evidence wasn't available at the time, and now it will be.
So what was the purpose of sending them to a special master? Just to fix that one little period, and then y'all could drag it out for another 2 years, and then at that point in time, we're basically back where we are. Because what the other option is to send you back to the special master for the hearing, because of the fact that I don't do this very often. I referred it to a special master to determine those issues. Those issues were determined. We had a hearing on the exceptions, and all of that became fixed. Now it has been, my order went down in 2023, I think. It was actually February of 2024. And we're now over a year later, and the argument's being made, my order on the exceptions fixed everything as of that day. So now we're back here saying that, well, we're going to reopen everything about the incomes and expenses and calculation of child support, which essentially means I'm going to be sending you back to a special master to cover all of those issues again, or else it was pointless to send you to a special master the first time. You understand what I'm saying?
I do, Your Honor, and I believe
We had the hearing, excuse me for interrupting. And we had the hearing immediately after the order was entered in February of that year. We could have tried to have it in July or whatever. Then it would have been a lot clearer. But now, essentially, reopening the proof to go into all of those same issues that were submitted to the master defeats the purpose of having a special master.
Yes, Your Honor, and we did not request that we go to a special master. We objected to that at the time. And, you know, I mean, it doesn't matter now, but here we are. But I agree that the special master hearing only resolved issues that only resolved the proof up through the special master hearing. I mean, it's been 3-4 years since then, and situations have changed, incomes have changed, child support. I mean, all those variables are fluid, and Your Honor can see from the different sections that were presented, the different time periods of when child support had to be determined because the variables changed between February of 2019 to June of 2021. There's like 6 different child support orders there because variables change. And so the proof, now, fortunately, I don't think there's going to be that many changes between June and 2021 now, but that proof hasn't been presented to the court yet. And that's all we have left to do. And the issue, the court still has to determine the contempt issue, civil contempt that my client filed. That issue was specifically not sent to the special master. And that would be from 2019 onward, those allegations of contempt. So that's where we are with that, Judge. 0 parenting days, that issue has been resolved, I would argue. Now, if there's been, I believe that Mr. Bailey would have the option to argue that he has since exercised parenting days to determine that calculation. But as far as the time frame goes from February of 2019 to June of 2021, I would argue that's the purpose of the special master hearing, and the exceptions and Your Honor's ruling afterward is those dates are closed. The proof during that time as to those issues are closed. Something I'd point out, Judge, is that these discovery orders were entered after the special master hearing. So we came before Your Honor before and said we are going to need supplemental discovery. We're going to need to show his income for the period after the special master hearing. It's relevant. Your Honor agreed, granted our continuance, and ordered that the parties supplement discovery. That was done after the special master hearing. That was done. One of these orders is 2023 and one is 2022. That's all I have, Your Honor.
Your Honor, again, on the issue of contempt, it is not ongoing. Petition for contempt states 4 payments. 5/1 of 19, 6/1 of 19, 7/1 of 19, 8/1 of 19. That's the only issue on contempt, as to whether or not he was willfully in violation of the court's order on contempt. The special master has already ruled that he was entitled to a reduction of $4,000 on the alimony paid during that period of time. And that should have been taken out of his income. So he was entitled to a reduction during that time. There are no, Your Honor, on the issue of contempt is simply on those 4 payments. Was he willfully in contempt of court? My client was ordered to pay an amount. He paid less than what he should have paid based on our calculations based on that he was entitled to. So that's the only issue of contempt before the court, nothing past that. And again, Your Honor, it was my understanding, again, when we came before the court on the first motion to continue, it needed to be bifurcated because you wanted to hear an order. You wanted to hear the objections to the special master first and then set it for a hearing. And then after that, I asked for a continuance in the March hearing due to when I broke my leg and had to have both my leg surgery for my broken leg and my hip replacement. So that was the last continuance. But again, the issue being is thereafter the court shall schedule a final hearing on the remaining issues and the parties shall supplement their discovery responses 30 days before the final hearing. There's not anything to supplement. Your Honor found that this is what my client's income was, and we don't dispute that. Again, there's not been a supplemental filing saying that he's had an addition, that there's a 15% deviation from the time that we had this hearing. So again, Your Honor, it's the convoluted time frame that we've been through causes these issues, but it's our position that parties had 3 children. My client was due a modification because of the alimony, number 1, then number 2, his income. The income of voluntary underemployment or willful underemployment was litigated by the special master. The special master found an amount of income. Your Honor modified that amount. And so again, that's what's owed. And we need a final determination of what's owed. But there's not a contempt on that issue, Your Honor. The issue is on the 4 payments.
Jack, you have the final say.
Thank you, Your Honor. There is a contempt on the issue in front of you, Judge, because that hasn't been ruled on by anyone. Even if he's entitled to a retroactive modification, we believe it's going to show that he still didn't pay. He still owes an arrearage. So either he violated the order that was in effect at the time by voluntarily reducing his own child support amount, or if the court gives him credit retroactively for child support modification, he still violated the order. But that's not what we're here for today. That's an argument to be made at trial because that proof hasn't been put on and Your Honor hasn't heard that yet. That's still pending. If going back to the discovery issue, if there was no discovery supplementation that was required or needed and income wasn't going to be an issue at trial, why did I receive an email this morning that had Mr. Bailey's 2023 or 2024 W-2 and his year-to-date income and through March of 2025? I think they're planning on submitting that to show child support and help the court calculate child support through May of 2025. But I would argue that that is not enough supplemental discovery. That is not all of his income. And just because, the income, there's been no proof offered at the court after June of 2021. We haven't received the discovery on that, and Your Honor ordered him to turn it over. That's the bottom line. It was ordered to. The rules of civil procedure say it's got to be, and here we are. It hasn't been again. Thank you, Judge.
Well, this case has been pending for a very long time, as has been pointed out, and it's not a simple matter. And that's the reason that it was referred to a special master. The issues that were referred to the special master are set forth on page 2 of the special master's report. Those issues include the following. 1, calculation of the parties' respective incomes from January 30th, 2019 to present. 2, the basis for any reduction of the petitioner's income, including any evidence of the petitioner's voluntary underemployment. 3, whether alimony payments made by the petitioner were considered and included in the respondent's income or deducted from petitioner's income at any point. 4, calculation of child support from January 30th, 2019 to the date of respondent's remarriage, November 2019. 5, calculation of child support upon the eldest child's emancipation. 6, whether the petitioner is entitled to a retroactive modification of alimony beginning January 2019 due to a change in federal tax law. 7, whether the petitioner is entitled to a modification of child support, and if so, from what date. 8, whether the petitioner is entitled to a modification of his obligation to pay 90% of the uncovered medical expenses based on a reduction of income. 9, the total of any arrearages owed by the petitioner for alimony and/or child support. Those were the issues that were submitted to the special master. Then those issues resulted in a special master's report being filed, and we heard on December the 19th, 2003, the exceptions to the master's report, which were filed by both parties. And the court took the matter under advisement, and I issued my ruling on February the 16th of 2024. That was filed with the court on that day. And then there was subsequently a motion to set a bifurcated hearing and some other motions that were filed. this court has recollections of this case, but it's for me to be able to say that I can rule on any of your motions, sua sponte today. It would behoove me to review the entirety of the file and to make a ruling, but I'm not going to probably be able to do that until tomorrow or the next day. So you're set for hearing on the 5th. We will reconvene on the 5th, and I'll tell you what my ruling is on your motions, but I cannot give you a ruling. This is my first day back in Cheatham County. I've not had an opportunity. We've had 5 jury trials in the last month. So we have not had an opportunity. I've not had an opportunity to be in my office to work on matters under advisement. So I'm going to take this file with me, and I'm going to review it tomorrow, and hopefully I'll be able to give you some definitive answers in the morning on the 5th. But I can't do any better than that. So I will take these matters under advisement. I can tell you that, as I stated, when something is referred to as special master, is to determine those issues so that the court doesn't have to have a protracted hearing on all of these issues. To then reopen because of the delay, these issues defeats the purpose of having a special master involved. So one option is send you back to a special master, which I'm reluctant to do because of the delay for one thing, and because of the expense involved in it in another. I'll look at these matters and I'll try to determine the best I can what the answer will be, and then we'll come back to you on the 5th. Hopefully, if I'm able to get an answer to your motions before the 5th, I will let you know by email tomorrow. Otherwise, it will be on the morning of the 5th.
Thank you, Your Honor.
Thank you, Judge. Do I need to prepare an order for today?
I don't think it's necessary until we see what I'm going to do.
Understood. Thank you, Judge.
All right, this is your motion to continue the final hearing that's set for tomorrow.
Yes, sir.
I'll hear your motion.
Okay. Judge, this matter has been pending since, October of 2023. However, since that time, there's been a lot of moving pieces and a lot of things have changed. And, but specifically for tomorrow, I have had, an issue with receiving pleadings, amongst other things, from opposing counsel's office. I am not here to say that anything was done purposefully. I just know that I represented Mr. Plunk back when we did this back in 2016 and 2017, and there were the same issues. I have repeatedly asked Ms. Myers to send me things via email, since apparently there's something wrong with my office getting US mail from her office. And in any event, despite what the certificate of services say about the dates that things were sent to me, I oftentimes either did not receive them until much later or did not receive them at all. I have gotten to know the clerks in the clerk and master's office very well, and they are very kind to, I get the pleadings from them because I can't get them from Ms. Myers. But in any event, on Wednesday, July 30th, I received a motion to set for final hearing. And that hearing was set for Monday, August the 4th. The certificate of service says that it was mailed to my office on July 18th, but I did not receive it until July 30th. I immediately reached out to Ms. Myers and said, your certificate of service says this. I am just now getting it. I am not available, with 2 business days notice, to be up here. But what was interesting, Your Honor, is throughout the entire month of July of 2025, she and I were in constant communication about trying to settle this matter and all of these other things. Never once was it mentioned. In any event, she told me that she would reset her motion. And I told her, that's great, just send me some dates. And then in part of the email correspondence, I said, in the future, can you please check with me prior to setting anything, just to make sure that those dates I'm available and can be here? And can you also email me things? So I get, Ms. Myers told me that she would obtain dates from the court. And it was my assumption, because what I was asking her was to reset her motion to set for final hearing. She sends me, I believe it was an email, and she said the court has these dates. So I said, November 4th, I can be there November 4th. But again, it was my assumption, because that's what we had discussed, was her resetting her motion to set. So, in any event, she sent, a proposed agreed order to me via email. And it was only then that I realized, oh, she didn't reset her motion to set. She set it for final hearing on November 4th. And so I emailed her and said, because she was asking me if she could sign my name with permission to the agreed order. I told her, hey, we need to talk, because I was under the impression this was the date that you were resetting your motion, like that it was not set for final hearing. I did not receive a response, and it wasn't until mid-October that I reached out to Miss Myers and said, are you still going forward on your motion to set on November 4th? And, or excuse me, let me back up. Yes, I asked her if her motion was still set for November 4th. She didn't respond. So I contacted the clerk and I said, can you please send me a copy of, was there an agreed order that was filed sometime around this time? And so the clerk was kind enough to, because prior to this, that entire week leading up to this, I had been emailing and texting and trying to call Miss Myers saying, we need to resolve this. We need to resolve this. We can simply do an agreed order. We have not finished discovery. We have not been to mediation. We have not done all of these things. She, would not, we could not reach an agreement. And so what I did was, that's when I filed this emergency motion. And then unfortunately, Ms. Myers, I think, was out of town for the 2 weeks after that. And so we weren't able to get a whole lot accomplished. However, the clerk's office did send us some final hearing dates to both of us, along with, an email that said, Judge Wolf has reviewed it. The soonest he can hear it is, because I was scared. I was nervous going forward with this motion on November 3rd, with the final hearing being tomorrow, because I'm not prepared. And so, it's okay. Miss, Jennifer in your office, and forgive me, I don't mean that really. I just can't recall her last name off the top of my head. She told us to contact Miss Rhonda, and we got dates. I sent them to Miss Myers, never heard back, never heard back, never heard back. And so, Judge, I am just here to ask you to continue this matter to a date that is convenient for all of us. And Judge, I'm also asking for my attorney's fees today, because we simply could have resolved this with an agreed order. Even this morning, I was running a few minutes late because traffic was behind. So I was reaching out to, your office to let you know that I was just a few minutes late. And even then, Ms. Myers said that she had no idea that the motion was set for today. She thought the motion was set for tomorrow, even though your office, the clerk's office, everyone had emailed her that it was taking place today. So in any event,
So what you're saying is if what we have here is a failure to communicate.
right, but Judge, it's not, well, I'm not quite sure what's going on her end. I cannot surmise. And again, I'm not here to say,
Well, the fact though is you're not ready for a final hearing and you did not understand tomorrow was the final hearing.
correct, until much, much later. Yes, sir. And, Judge, so here we are. I have attempted, to communicate I will tell you the biggest probably piece of the puzzle is, the parties only have one minor child remaining. And, he, contrary to the parenting plan that was entered in 2017 by agreement, he has left my client's home and refused to return. The child is 17, he is unruly. And so against the court order, Ms. Meyer's client is not sending the child or forcing the child to go. And which is, that's fine. However, now we're dealing with the issue that, her client now wants retroactive child support to the date that he moved back in to mom's home, contrary to the court order. So now that I've learned that, I'm going to have to do a lot of discovery. A similar thing happened, prior to the, party's oldest child emancipating. We entered an order in 2017 and the daughter was 17 years old at that time. And so we put a provision in the parenting plan that due to her age and maturity level, that she was under no obligation to, adhere to the parenting schedule, laid out. And so, but we still gave Ms. Meyer's client credit for 182.5 days for both children. However, the child never returned to her mother's home. And so if their position is not, which is not what is in their initial, petition that she filed, that petition has not been amended. However, if her client is now going to be seeking retroactive child support back to the date that the child unlawfully stayed at her client's house, then we're going to have to go back to 2017, 2018. I'm going to have to file a counter petition that says then my client wants that money from that time as well, when the daughter did not, visit with the mother, even though she was given credit, which is the same exact argument that her client is now using with the son. So, and I will say that it does not prejudice her client at all, to reset the hearing because she is in physical possession of the child. And she's also now, we entered into an agreed order where my client is now paying child support based on the client being in her home full time. So it's not going to prejudice her at all. But it would, very much so prejudice my client if we were to go forward tomorrow.
Right.
Thank you, Judge.
Your Honor, this is the first time in 23 years that I've been accused by a counsel of not sending out documents like I stated in my certificate of service. She did ask me to email her. I did email her. I've got the emails here. After she sent me an email claiming that my motion to set was rescheduled, I contacted her when she asked that I reset my motion to set. I contacted her, verbally spoke to her. She agreed that there was no reason for us to come on a motion to set. We could agree to the date of the final hearing. I then prepared an agreed order, sent it to her. I've got emails to show to the court. Twice I sent it to her before the court date on my motion to set. Both times she did not respond whatsoever. So where she claims she doesn't get my mail, she obviously also doesn't get my emails. So I sent it to her on 2 occasions saying, we're setting the final hearing for November 4th per our verbal conversation, and did not hear back from her. I then came before the court on my motion to set and set it on the date we had agreed to. Then, yes, she has reached out to me several times about setting, entering an agreed order as to resolution of this case. My client has not agreed. I've made offers. She's made offers. There has been no resolution. That is not the fault of my client. That's not the fault of her client. There just isn't a resolution. We're going to need the court to assist in this. As far as setting tomorrow, she's asking to reset it because there hasn't been discovery done. My petition was filed on October 5th, 2023. That is over 24 months ago that they had the opportunity to give us discovery and ask for these things. The proof, they've argued the case. I'm not trying to argue the case, but the fact is, father kicked the child out, sent my client a text and told him that he was coming to live with her. So he did come to live with her almost 2 years ago, a year and a half ago. This child will be 18 in January. We had to come to court and file a petition to set child support because he refused to pay anything for this child in that amount of time. He's only paid a few months worth of child support. We contend that they agreed to this date and that the only issue that's going to be when the court continues, and I recognize the court's going to continue it, but that the only issue remaining is what child support he owes for all this time, because the child's going to be 18 years of age. She contends that she agreed to a date. She wants to set it off till March. This case hasn't been heard by any other judges, and there's no reason to put this case off another 6 months when it has already been over 2 years. So we understand the court's going to give us a new date, but we're asking that it not be 6 months from now. Thank you.
Well, I think at least what we have here is confusion or lack of agreement on what was taking place tomorrow. And frankly, the local rules do require mediation or waiver of mediation, and Judge Lockhart Mash apparently signed your order to set the case in front of me, but there was no indication of having waived the requirement of mediation by this court. It doesn't sound like from what Ms. Myers is saying that mediation would likely be successful in this case. I'm going to grant the continuance, but I'm not going to reset it for March. I think it can be reset more quickly than that. So what dates do you have available?
And Judge, if I may just respond to that, I was sent, I think 5 or 6 dates by your office, and that was just the first one I was available for. It wasn't, I didn't ask for it.
So you don't have any availability until March?
No, sir. On those specific dates that she was sent to me. Absolutely, I have availability before then. The only thing I would request is just time for, I personally do believe mediation might be successful.
You've got some dates in January. We're in the beginning of November. That would give you ample time to get your.
Absolutely. And just with the understanding that because I will have discovery to Ms. Myers by the end of this week, by the middle of this week.
January 8th, 9th.
I'm sorry, I'm on the wrong month.
Both those dates are available for me, Your Honor. Your Honor, I don't have discovery even today, so if they wanted discovery, they could give it any day.
I'm sorry, ma'am.
Half a day.
I think it's gonna be a full day.
I don't see why. We've got 1 month. So this child will be 18 when we come to court.
No,
Sorry
in a-
about that.
In a year.
We're gonna be talking incomes.
January 29th.
Hang on, Judge, I'm sorry,
I can do all 4 of those dates.
Did you say-
9th, 28th, or 29th.
28, 29 is what you said, I'm sorry.
January.
Okay, I'm sorry, trying to. 29 would be great for me.
29th.
And will that start at 9 AM, Judge?
Pardon?
Start at 9 AM? Okay, and it will be here? Okay,
All right. I'm granting your motion to continue. The case is reset for January 29th. I expect council will agree on whatever discovery so that you can get that completed within the next 30 days.
Yes, sir.
or so. All right, we stand adjourned.
Thank you, Judge.
Thank you.
All right, this is an appeal from General Sessions Court, and therefore it is a trial de novo, which means you start from the beginning, just as though the hearing in General Sessions had not taken place. So you will need to put on your proof. And Mr. Friend, you have a seat there. Seat at the table, please. Sit at the table. Yeah, here. All right, so you're here today on your appeal from General Sessions Court, so this is your opportunity to explain to me what this case is about and why you are entitled to any sort of judgment.
Yes, sir. On April 25th of 25, John Friend signed, a documentation selling me the vehicle, and, we were dating at the time, and then he became aggressive, and I was on the phone with someone, and he told me to get my effing butt inside.
So you have the title to that vehicle?
I have the title, he changed the warranty over to me. I had the vehicle at one point in time, and then he come and stole it because he had a duplicate title brought up, and then they had keys made when I was out of town.
All right, well, let's back up. You and he were dating?
Yes,
All right, what time frame was this?
we dated for about 5 months, and it was like,
When?
let's see, 2 months prior to 4/25 is when we started. And a couple months after this is when, 4/25 is when we stopped because he was being aggressive.
All right, so while you were dating, where was this vehicle?
It was with us,
It was with you?
yes,
And it's a 2014
Buick,
Buick?
yes, sir.
All right, and who bought the vehicle?
It was his vehicle at first. I bought the vehicle
All right,
with money that I had, with my mama.
so you supplied the purchase price money for the vehicle?
Yes,
All right, how much did you
25.
pay for it?
$25,
$25?
25, 2,500.
All right, 2,500, all right. Show the deputy, hand that to the deputy, whatever it is that you
And then
you
that's the
prefer.
warranty too. And when I went to go try to get the title or put in my name, the lady gave me this title number and said he has either got the title before or got the title after he signed that title. He got a duplicate title.
Now, this certificate of title that you've given me shows that it is in the name of Jonathan Friend.
Yep, if you flip it over, he signed it over to me and I
Just
tried
wait.
to.
Let me give you some advice. I'm gonna ask you some questions, so you just be quiet while I'm asking the question, then we'll let you answer, okay? And then there is a signature on the back that says Jonathan Friend, where it says the signature and address of the seller. Are you testifying that that is Jonathan Friend's signature?
Yes, sir, he did all.
He signed that,
Yes, sir.
and you paid him $2,500 for that vehicle.
Yes, sir.
And how did you pay it?
Cash.
Cash, all right. And did you have this title turned into the clerk's office?
I tried to, 2 months afterwards, because that's when I got more money, because I started working. And they told me he went and got a duplicate title, which that little piece of paper I just had right here. The title number had changed to 111011649 and that's the title I had to have. So he had went and got it after he sold me the vehicle. Or before.
All right, so you have a title that was signed, that according to you was signed by Jonathan Friend,
Yes, sir.
and then you also have the
The warranty that he changed over.
final notices, I think it is for the insurance lapse,
Mhm.
and it is sent to you,
Yes, sir.
and that date is June 11th of this year. Is there anything else that you would like to say about this case?
Yes, sir. I also reported my vehicle vandalized on 6/23/25 when I had it. Okay. I also reported the vehicle, because it wasn't in my name, the title's not in my name, so they put possible stolen vehicle on 8/22/25. And, let's see. I think that was written in the General Sessions Court that I went to. And if I stole the vehicle, why didn't he report it stolen? I mean, I'm the only one that reported it stolen.
All right. So you reported the vehicle stolen because you had the,
I
when
had the
you,
vehicle.
all right, just a second. You had this title that was transferred to you, you and he were together,
Mhm.
and that occurred while you and he were still together?
Yes, sir.
And then you broke up.
Yes, sir.
And when did you break up?
It was sometime May, the end of May, beginning of June.
All right, and when you broke up, where did the vehicle go?
I took it. I left. He took the clicker thing to unlock the doors and stuff, but I took the keys. I threw my clothes and stuff out the top window of where we was staying because I was scared of him, how he treated me the night before. And
Yes.
so when I did, I took the car and I left. When I left, my vehicle got the tires flattened and the seats slashed. The only person that could get in that vehicle that had that was him. He had the clicker. I had the keys. He had the clicker. So I took the vehicle from where it was at and hid it. And then went and read a report. Took pictures down to the police department, showed them everything. When I went out of town to Dixon to work for some people down there in their resort, I come back and 4 days prior after I got back, my vehicle had been stolen 4 days before the court case. So I had tried to go to the court thing to add that on there, but I didn't have the money to add that he stole the vehicle and I wanted my vehicle back. So I just did type.
All right. So how long after you two were separated and you went on your way, did the vehicle turn up missing?
About 3 months,
Okay.
because I had it hidden in a barn.
Mr. Friend, you are acting as your own lawyer. You have the right to come to the podium and ask questions, but they are not to be made statements. You have to ask in the form of a question.
You have a bill of sale?
No, because you ripped it up when you snatched the keys off my neck.
Do you know the definition of perjury?
I do know the definition of perjury. Do
Okay.
you?
Have been getting reported. When did you say this vehicle was stolen out of the barn?
The vehicle was stolen like prior to 4 days before the court case.
What,
Actually, hold on 1 second.
I'm asking for a date.
The vehicle was taken because I talked to Steve, Armand, that where the work's at. On September the 8th is the day that I actually, hold on, wait. Where's that date? Where's the file date on here? That's the set date for the court. August 28th, 2025. That was when it was taken out of the barn.
Okay.
Supposedly when Steve Arbridge told me that he came with, somebody to make keys and a friend.
There was a locksmith, yeah. When you took off with this car, you said you threw stuff out the window and you was afraid of me?
Yes, I threw all my.
Had I threatened you?
Yes, sir. You told me to get my fucking ass back in the house right fucking now. You said last night, or the night
You-
before. And I was
One
on the
time
phone
I'm
with-
gonna ask you, do you know the definition of perjury?
I was on the phone with somebody that heard you.
I mean, there are witnesses to what happened that day. You do know that.
No, there's not, because it was just me and you. There was nobody else there. It was me, you, and my dog.
Okay. So when I went down to the shed and was working and you loaded up the car after you said you was gonna go do laundry and you took everything,
I didn't take
And
everything. I took all my clothes, my dog, and my pillows, and you still have half my clothes, my ice maker, my dead aunt, jury ring, and I'm not asking.
Let me
for
remind you both, I'm not here to decide, I'm not here
No,
to decide.
I
Wait
understand.
just a second. I'm not here to decide whether or not you two, who was at fault in your breakup. I'm here only on one issue, and that is the ownership of this Buick, 2014 Buick.
Okay.
I'm holding a title that bears the signature of a seller, Jonathan Friend. So I need to know, your questions need to limit, when I'm talking, you be quiet, okay? So limit your questions to what it is that you think applies to the question of the ownership of this vehicle.
Okay. Can I ask a court a question? Is there some leeway since it's civil over criminal?
Is there some relation civil over criminal?
No, I mean, the leeway in questioning to bring it all together, what was happening.
Well, if it relates to the ownership of this vehicle, then it could be admissible. It might be relevant on that. But if it doesn't have anything to do with the vehicle, I don't want to hear whether or not she took everything out of the house. All I want to hear is I've got a title to this vehicle that seems to be signed by you. And I need to know whether or not, what the argument is about and whether or not you believe that is your signature or is not your signature.
It's just, I don't know the relevance of the other things that were happening, as far as, when the time, well,
Just ask questions of the witness.
okay, okay, sir. So I don't want to ask her questions. I don't want to hear her voice. I really don't.
Do you have anything else to say?
No,
Thank you. Step down. Mr. Friend, do you have any other witnesses, Ms. Wells? Mr. Friend, do you wish to testify?
Yes.
Then come around and be sworn.
And I hear.
You sit right there and listen to what he says, and then I'll give you a chance to ask questions.
Okay.
First of all, you need to stand up and raise your right hand and be placed under oath. All right, I'll hear whatever you want to say about the ownership of this vehicle.
Okay, at the time this was all going on, I did have a concussion. It had happened, I fell in the shower at her mother's house, bumped my head. And part of it is foggy. I did turn it in as stolen, both in Robertson County on the 1st of June, I believe it was. And then also in Cheatham County, I talked to Tim Binkley personally, and they were looking for the vehicle all the way back as from the first week of June in both counties. The other stuff that was taken, whatever, but she wanted to buy the car. I had a deal on a car that if I could sell it that cheap, because the car is priced right now at $5,900. But she never paid a dime. She's still not paid a dime for the car. That's why she didn't have a bill of sale. When she wanted the title, and we were sitting there talking about the title, then I said, pay for it. And she said, well, if you'll give me the title, I can take it to a loan place and get the money for you. And I said, I think I better hang on to this. And then the night before she took off with the car, I had told her I had decided to trade it. I had already talked to Tommy over in Guthrie, and I was going to trade it for something that would pull a camper, because I got a camper. And she took off. She also she stole the title. She stole my wife had died in October 29th at 4:17 p.m. And she called me in March, I believe it was, and said she was calling to check on me. And she told Cindy she would, because we'd been so good to her and her boyfriend. Then she called again a few weeks and asked me if I could come get her because her boyfriend had put his hands on her. And I went and got her. So the 5 months she's talking about, it was really probably the last week of March, late third week, and into May 29th is when she took off with a car. On the 31st, which was my birthday, she'd taken out a Cash App card. I'm not even aware of these things. Had it delivered to her mother's address and had cleaned out my pension account when it went in the bank on the 31st on my birthday. I was supposed to go play golf with my son that day, and she took the golf clubs, to my 2 sets of golf clubs with her. Then on that Monday would have been Memorial Day. So I did talk to the Deputy Ortega over in Robertson County, on the, I guess it was the, well, it'd have been the first. And he told me how to proceed with it. And at that point, I turned the vehicle in as stolen. The title turned in as stolen. And then on the Tuesday, I found out that, like, I called my bank the day after the holiday and because they told me that the 160 been taken out on my birthday, and I stopped everything, and then they told me there'd been another attempt to get $600, and then another attempt to get $300. And um, and prior to this, like on the 26th or so of May, I had got a credit card bill for my wife for a brand new credit card. And I called them because she had passed away in October, the 29th. And I was just, all I asked them was, just, can you tell me the issue date? Because she's gone. And they wouldn't, because I wasn't the primary on the account. And she kept trying to get me to stop asking questions and drop that. And I couldn't figure it out. But when she took off in the car, I had told her I was trading it off on Tuesday. I'd already talked to Tommy. And I was investigating where these credit cards, what was going on. But when she took the title, it wasn't given to her, and she never paid a dime, not one penny ever. But she had taken my wife's driver's license, her social security card, her birth certificate, and tried to take out a $1,000 loan and 2 credit cards. I think that's mine. I'm sorry. I thought I had the battery turned off. I just brought it in because there's pictures of it. There's pictures of the barn and the vehicle. The vehicle was in there. The tags had been taken off. When Steve Romans, him and Trey Watson, who works for him, found it. Trey, I coached in Little League over here in East Cheatham in baseball and basketball. And then they were over at Susan Heron's, and they were talking about they'd found this Buick. Well, these people over there knew I was looking for my Buick. And they told Trey it was mine, and they called me. Steve Romans called me then. He's friends with my son-in-law and his dad and my brothers, and anyway, and told me where it was, and I went over, and it was my vehicle. I then got a locksmith. I spent almost $500 to get in it and get it going. Then I had to buy 4 tires. It had been run off the road and hit the wheel wells were messed up. And they told me that the tire place that it had been driven on flat tires, they could tell by looking at the old ones when they pulled them off. And I got the vehicle back on like the 12th, 14th. The 12th is when I was notified they found it. On the 14th is when I was able to get it back to the house, and I started fixing it. And I fixed the vehicle up, and then I went and did exactly what I'd said on the 29th of May, and that was I went over and seen Tommy and traded it off. Just like I'd said, I got the new title because that was told. The Deputy Ortega and Tim Binkley both told me that would be the thing to do, because she had never paid for this car, never paid a dime, never even tried to, never worked. And we weren't together no 5 months, it was about a month and a half. And there wasn't a relationship other than she was going to comfort me from losing my wife and going to take care of me and help me. And if I just sign it over to her, she was going to be there to drive for me anyway. And when I started to hand it to her, I thought, the hair stood up on my neck, and I thought, I believe I'll hold on to this until you get me the money. And that's where it was when she took it out of my box with my wife's ID and everything else, and then proceeded to use that to get credit cards and try to get loans and other things. And I've been dealing with it ever since. My banks, I had to close all my accounts. I had to close all my credit cards. I'm still dealing with it. I got my Social Security check this month. Is the first time since June. And I didn't get it in June, but since then I got my check on time. My pension check is still in the wind and I'm waiting for
This
it.
case doesn't have anything to do with
Well,
your social
it's-
security check.
But it's all part of the whole pattern. It was a scam. The whole thing is a scam. That's what she does. She's on probation for stealing in Springfield and for drugs here in this county. And I was just a patsy. And she used my wife, who had just died, and talked about a friendship to her and everything else. And that just goes all over me. I mean, it was the 29th, it's just last week, it was 1 year to the day. I tore up, I spent a couple of days just in pieces. I miss her so much, man. And she used that to get to me and to get these things and set out to steal all these things I'm bringing up. It was not like it's just abstract, oh, I think I'll do it. This was it's a pattern of this person. And if her record shows that, I've never been in trouble. I coached ball around here. I fixed ball fields. I built the softball field at Cheatham Central and all those fields at Sycamore. My company did all that for free. It changed the lights in every ball field in the county for a year for free. My daughter teaches at Sycamore. She teaches math at high school. My son's a Green Beret stationed at Fort Campbell. You can ask anybody around. You can ask Tim Bingley. Tim's one of the first people I called because I've known him since he was a DARE officer, you know, and he helped with the kids that we had a blind fund for kids who couldn't afford stuff and we bought it.
Right.
And I know that's got nothing to do with it, but the vehicle, she never paid for this vehicle. She never tried to pay for this vehicle. It's all a lie. It's a blatant, that's why I asked about perjury, because she's lying. She never paid a dime for this vehicle. Otherwise, she'd had a bill of sale. It's as simple as that. She would have had a bill of sale. I wouldn't have neglected that. And I didn't tear nothing up and I didn't go after her. She started hitting herself one day and I told her, you ever do that, even kind of do that. I don't do that. I've got 4 daughters. I've been a widow twice in my lifetime. I've never put my hands on a woman and I wouldn't.
All right.
And I've never threatened one either.
Ms. Wells, you may come to the podium and I'm going to remind you, questions you need to ask are directed to him regarding your complaint in this case.
Did you sign the title, John?
Hmm?
Did you sign the title?
Did I find it?
Did you sign the title?
When I had a concussion.
You didn't have a
told me you had the
concussion.
money?
You didn't have a
Yeah, you told
concussion.
me you had the money.
No,
You
I
didn't.
paid you already.
Stop talking, both of you.
Did you give the title to?
Okay.
Oh, sorry. I thought you were just talking about just.
Show this to the gentleman, Mr. Friend. Is that your signature on that document?
It could be.
Could be.
But like, yeah, I mean, I've got the paperwork with me. I had a concussion and I was out of it for a month. But the point of it is, I remember sitting there and we talked about this and I remember I was signing it and I said, what about the money? She said she didn't have it. So I said, I better hang on to this and I put it in my lockbox. And it's just a cheap one you can open with a pocket knife. But I put it in there with all of my wife's stuff. And it was all gone when she took off. She took this.
All right, hand that back to the bailiff. As well as have a seat.
Thank you, sir.
And I got a new title because that was what suggested.
Mr. Friend, step down. Stop talking.
Okay.
This lawsuit that was filed by Ms. Wells seeks one thing. Tanya Wells for the title of the 2014 Buick, court costs, etc. Court finds that the title to that vehicle has been signed over by Mr. Friend to her. And therefore, I find that the title to the vehicle belongs to Ms. Wells. Do not make any finding regarding the payment that you allege was made or was not made by that. Nor do I make any finding for the possession of that vehicle, because that was not something that was sought in this lawsuit. The only thing that was sought in this lawsuit was the title to the vehicle. So I've now found that the title to the vehicle is in her name. If she seeks to have that recovered, she'll have to file a different lawsuit seeking to recover the actual physical car. And if she does that, you then have the right to file a counterclaim against her for the $2,500 that you claim she did not pay. Then it will be incumbent upon the plaintiff, Ms. Wells, to prove that she actually paid that $2,500, and you'll have your right to prove that she didn't. But right now, the only thing I have before me is a lawsuit seeking to recover the title to the vehicle. Title to the vehicle has been signed by you and by your own admission. I've looked at the signatures. It is your signature. I've compared that signature to the form that you filled out for the appeal in this case from General Sessions, and it is your signature. So the fact you signed the title means that the title passes to her. But it shows a consideration of $2,500, and that's a separate issue. So is the physical actual possession of the car is a different issue and would have to be brought under a different action. So you two can get together and try to work this out, or you can bring separate lawsuits and keep fighting it out in court. But at this point, the only thing that I am ruling on is the fact that there was, in fact, a title transfer to Ms. Wells. I make no finding regarding the $2,500, whether it was paid or not, nor do I make any finding as to whether or not she is entitled to the vehicle without that. She may be entitled to the vehicle under the law because she got the title from you, but you would still have the right to bring an action against her for $2,500 for the purchase price you claim she never paid. So I wish I could solve all your problems, but that's the best I can do.
Can I ask a
Thank
question?
you, sir.
I apologize. I can't even one thing. I'm sorry, you know. The only question can I ask a question?
You should ask the question.
If the title wasn't given to her, it was taken from a lot situation, does that transfer of title in that case?
You signed the title to her, and that's all I'm making a finding is that you signed the title, and therefore the title to the vehicle was transferred to her. That's the issue about how the possession of the vehicle occurred and all is not something that's before me. The only thing she asked for in her lawsuit was to recover the title. So I've made my finding. You two can cash it up.
Thank you.
You excuse my ignorance, that's why I just.
All right, this concludes our circuit court civil docket call. We'll come back to Chancery at 10:30. 2013 CV 15737, Kenneth Ray Spann Jr. versus Amanda Michelle Spann.
Your Honor, that's here on my motion to continue. I think Mr. Dennis Stanford of the Parksville Bar should be on Zoom.
He is in the meeting.
I should be up there now.
Right.
Your Honor, I was just retained by the previous Mrs. Spann in this matter. As I understand the history in this case, the parties were divorced some time ago by this court. The parties have 2 minor children. This matter, there's been a previous modification before the court that was settled again by mediation. I don't believe there was a hearing involved in the past one. This was filed originally, I think it's a pro se matter by Mr. Spann in the juvenile court of Cheatham County here. At the time, Mr. Kurt Vandervoort was retained by my client. He filed a motion to dismiss that matter. That was dismissed, and then I think Mr. Stanford got involved in it and filed a petition on behalf of his client, Kenneth Ray Spann, with this court to modify. A copy of that, according to some filings that I found out on Friday, was forwarded to Mr. Vandervoort, but he did not accept service of process, and as I understand it, relayed back to, I think it was Mr. Stanford's assistant, that he had not been retained in a chancery court matter, only in juvenile, and did not accept service. After that point in time, Mr. Stanford forwarded process to my client, who is now a resident of Hawaii, and a private process server served that. When I called over here to check to see if there had been service made, there was nothing indicating in the record that service had been made, although the motions were set for tomorrow. As your honor's aware, several of the judges in our jurisdiction have chancery days on the same days. I'm scheduled to be in front of Judge Suzanne Lockert Mash tomorrow with 5 matters on the chancery docket in Dixon County. I scheduled to be in front of your honor on Wednesday. So I am not available to do this matter tomorrow. My client was simply served week before last by process. She is in Hawaii. The matter's not at issue, and if your honor reviews the pleadings, although all I have filed, your honor, is my notice of appearance, but I will be filing a motion to dismiss the temporary motions. I have not had an opportunity to do that yet, but I'm just not available tomorrow.
Mr. Sanford, Ms. Roberts is filing a motion, has moved to continue based on her unavailability. You want
Yes,
to be
sir.
heard?
And, well, the case has kind of bounced around. Mr. Vandervoort agreed he would accept service. It was sent to him. Then I was told he did not represent former Miss Spann. And then I was told he did. So it's kind of gone back and forth, and my client's gotten frustrated with it not moving forward. I don't oppose Miss Roberts' motion to continue, but it was my hope that this could be moved to another county. I understand there's a date in Stewart County. I don't know the exact date that you'll be there. And then there's another in Houston County in late December. And that should provide Miss Roberts time to prepare. I don't disagree with any of her account as to what happened, and nothing I've said in any pleading was directed at her. She'd only been on the case for about 3 days, and she wouldn't have any responsibility for any of this bouncing around or delay. I just like to get this case heard as soon as possible. I understand the reason for continuance. I would have filed a motion to continue myself under the circumstances. I just like to get this case heard as soon as we can.
I'm going to grant the motion to continue based on good cause shown, and obviously, Mr. Stanford, I know you well enough to know you agree that there is good cause. As far as setting it out of the county, I'm not going to set it out of county on one of my days, but you may have to check with one of the other judges. We've got 4 now, so when is your next judge here in Cheatham County?
Your honor, and I'm not aware of anything that would require you to hear it. I think on the initial pleading that Mr. Stanford filed, he put your name on beneath the
I have no.
docket number. You signed the mediated agreement, but there wasn't a hearing associated with it, and this is a new matter. So I don't see, and again, it's not at issue yet.
Well, I don't have a possessory interest in any of these cases unless I have heard temporary matters that would weigh on the final hearing. So I'm of the opinion you can get an easier date more quickly.
Sir, I'll work with Ms. Roberts to identify a judge and a court and a date. I'm happy to do that.
Do you want to do it now while we're all here?
What, to reset his motions? Is that what we're,
We're resetting your motions, is that correct, Mr. Stanford?
Yes, sir.
who was here in December? I have a child support matter, a Kittrell, set on the 15th. And I don't know who's in, it will be Judge Turnbow. I think he's in Dixon County in December. And I have a matter on the 15th. Of December.
We have one day in December?
Mhm. What days did you have in January? That's Judge Wolf's Chancery Day, and I already have 2 matters set in front of him. The 9th is fine.
December 15th would be fine with me.
Well, Ms. Roberts says she has a court in front of another judge on that day, Judge Turnbow, so.
And if it happens to fall through, I will check and see if if I can get it resolved. I don't mind setting it if there's time, if Judge Wallace will allow us to set it. You know, he makes me ask permission.
All right, January 9th, subject to having it moved to an earlier date if it falls, if it is available.
Yes, sir.
All right.
Thank you, Your Honor. I'll do an order.
Thank you, Ms. Roberts.
Thank you, sir.